Businesses that rent their commercial premises should be aware that the landlord's right to implement the common law self-help remedy of distress for arrears of rent was abolished on the 6th of April. It was replaced by commercial rent arrears recovery. Before the 6th of April, a landlord of commercial premises could instruct a bailiff to seize a tenant's goods for arrears of rent. Rent was defined as the amount of rent payable under the lease plus VAT and any other charges such as service charges and insurance premiums that were reserved as rent in the lease. No notice was required before a bailiff could appear at the premises. When commercial rent arrears recovery came into force, this implemented several changes to the process. From now, landlords will only be able to recover pure rent plus VAT, excluding any service charges or any other charges made, such as insurance premiums, even if they are reserved as rent in the lease. Bailiffs have been replaced by enforcement agents, who are required to give 7 clear days' notice of their intention to arrive at a premises. This excludes Sundays and bank holidays. An enforcement agent can either remove or sell the goods or enter into a controlled goods agreement where goods remain in the premises but become the custody of the enforcement agent pending return to the premises. In order for rent to be recoverable under commercial rent arrears recovery, a minimum of 7 days net unpaid rent must be due. If the tenant pays the full rent or part of it to reduce the balance to less than 7 days between the service of the notice of enforcement and the enforcement agent attending the premises, then the right to continue with commercial rent arrears recovery will be lost. The notice period for an enforcement agent's intention to visit premises could provide the tenant with an opportunity to remove their goods to avoid enforcement. If a landlord believes there is a risk of this happening, they may apply to the court for permission to reduce the notice period. The full details of this have not been clarified yet. For further information, please contact us.